Lost of love. It's better to have loved and lost than never to have loved at all. Come cheer up my lives, come cheer up my lives. It's better to have loved and lost. It's better to have loved and lost after John Carter than never to have loved at all. The Federation Starship, come cheer up my lives, come cheer up my lives. It's better to have loved and lost after John Carter.
Okay, everybody, welcome to the Week 1 Professional Responsibility video lecture. The point of these lectures, these video lectures, are to at least go over the rules that are going to be applied in class concerning the exercises that we'll be doing in class. For the first week, Chapter 1, there are 3 fact patterns towards the very beginning of the chapter that are called discussion problems, and we will be going through those and having to answer those discussion problems using and applying the rules of professional responsibility. And those rules would include the ABA model rules as well as the California rules, and also case precedent as well. The first chapter goes through a lot of there's a lot of writing about self-regulation, the myth of self-regulation, legal ethics fall apart, and all the differing sources of the control and administration of professional ethics and responsibility when it comes to the legal industry, and what a lawyer needs to know, especially how to behave ethically. I think the first chapter basically says, hey, there's a lot of stuff out there. You need to be aware of it. And also criticizes some of the regulations because some of the regulations conflict with each other, not necessarily conflict within the model rules or the California rules, but outside sources of regulations, such as certain types of federal regulations, state regulations, local regulations. But they especially, I think, have some good criticism of federal regulations, because federal regulations are so far removed quite often from the day-to-day practice of the legal profession that when they put these federal laws out there that impact the day-to-day conduct of a lawyer, they don't really even know that they're doing it or take it into consideration. And thus you can see some of the conflicts of interest concerning certain regulations when it comes to property forfeiture and things like that, and how it may affect whether an attorney can actually represent certain clients and how they'll get paid by certain clients. But when you remove the concepts of subsidiarianism, which means that those persons who are closest to the decisions should be the ones governing those decisions or making those decisional choices, when you remove that and send it away to a faraway body in Washington, D.C. when it comes to the U.S., and then those decisions in Washington, D.C. have broad application and a broad effect on the everyday life of people, they don't even know that this occurs. They're just up there trying to save the world, I guess. That's what all these members of Congress and the deep federal state that has been created in the United States has come to. So read the first chapter. We will definitely be going through the Ricoh Mitsubishi Motors Corporation, and I also will be sending you, you should receive this, a California case concerning an advocate or a lawyer testifying. So let's start out now with the rules that we'll see applied and for the first chapter. The first thing we want to talk about is the client-lawyer relationship, Rule 114, and that has to do with client with diminished capacity. There is an A, B, and C part of this. The Rule 114B seems to be the applicable one to our reading, but let's just go through the whole thing. It says, when a client's capacity to make adequately considered decisions in connection with representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So as much as possible, the lawyer wants to treat every client normally, maintain that normal relationship. But sometimes that normal relationship, due to diminished capacity, just cannot be met. So for B, it says when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. So as you can see in B, there's a lot of things. Is the client at risk for substantial physical, financial, or other harm unless there's action taken? The lawyer may take reasonably necessary protective action, and that includes talking to other individuals, and it can also have the lawyer seek the appointment of a guardian ad litem, conservator, or guardian. That means someone who can make decisions for the person who has the diminished capacity, where the normal client relationship cannot be met, and also where the client is in danger, physical, financial, or other types of harm. And C is information relating to the representation of a client with diminished capacity is protected by Rule 1.6. Rule 1.6 is the confidential information rule. We'll talk about that. Say, when taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. So basically what that's saying is, look, there's confidential information that you've acquired in your representation of a client. You're allowed to reveal that information about the client, but you need to be careful. You can only reveal such that is necessary to protect the client's interest, and oftentimes the information that you're going to be revealing is adverse to the client, so you have to be especially careful when you are revealing adverse information about the client. And we'll look at Rule 1.6. Here's a warning in the comment sections of 1.14. Comment 8, it says, disclosure of the client's diminished capacity could adversely affect the client's interest. In our discussion problems, we have such a fact pattern, such a situation where the client is a drug addict and there's harm to himself and maybe his daughter, and the client is diminished in capacity. So let's go on. It says, for example, raising the question of diminished capacity could in some circumstances lead to proceedings for involuntary commitment. Information relating to the representation is protected by Rule 1.6, and that's confidentiality of information. Again, we'll talk about that. Therefore, unless authorized to do so, the lawyer may not disclose such information. Now, this is not very clear, this rule, when you can disclose such information, but it seems to say that it's implied that you can do so. So in this comment, in the italicized words, it says, when taking protective action pursuant to paragraph B, and remember, paragraph B is where you can seek to protect your client and even get a guardian or guardian ad litem. It says, when taking protective action pursuant to paragraph B, the lawyer is impliedly authorized to make necessary disclosures, even when the client directs the lawyer to the contrary. Okay, so impliedly authorized to make necessary disclosures to protect the client who has the diminished capacity and the normal client relationship cannot be met. It says, nevertheless, though, reading on, given the risks of disclosure, paragraph C limits what the lawyer may disclose in consulting with other individuals or entities or seeking the appointment of legal representative. Okay. So then it goes on and says, at the very least, the lawyer should determine whether it's likely that the person or entity consulting with will adversely will act adversely to the client's interest before discussing matters related to the client. So the thing you want to do is, look, you can't just spill the beans on this person and say everything you know about this person that you have learned concerning your representation of that person. Whether the person has said it to you or other persons have said it to you. You have to be careful, and you need to focus on what type of help do you want for the client. What type of help does the client need? And thus, you are impliedly authorized to make such disclosure about that. And it also warns you, well, am I going to go to the police with this? And are they going to arrest him? Or am I going to go to somebody who's going to give my client help? Okay. Now at the bottom it says the lawyer's position in such cases is an unavoidably difficult one. Okay. So one of the things you can do is you can seek counsel concerning your professional responsibility under this and how you can act according to the laws. So you can always seek you can always seek input from those who can consult you or can provide you with advice concerning your ethical responsibilities under the rules of professional responsibility. And we'll see that in Rule 1.6. Rule 1.6 is confidentiality of information. And we'll go through the difference between privileged information, confidentiality of information, and the work product rule. All three of those impact Week 1 and the study of the rules that we are going over in Week 1. So here it's a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. So A, if you have consent, or it's impliedly authorized in order to carry out the representation of the client, some confidential information, but only that required, can or allowed or given consent to can be revealed. Now, B gives exceptions. It says a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm. Okay, so if you find out information that could prevent certain death or bodily harm to your client or to someone else, you're allowed to reveal such. To prevent client from committing a crime or fraud. Okay, that's 2. To prevent, mitigate, or rectify injury to the financial interest or property of another. Okay. Here's 4, to secure legal advice about the lawyer's compliance with these rules. So we talked about it earlier. When you're seeking under Rule 114B, what it is you should do concerning the diminished capacity of your client, you can seek legal advice about the compliance with these rules and what it is you can do and cannot do. 5 is to establish a claim or defense on behalf of the lawyer. That's in malpractice claims. 6 is to comply with other law or a court order. That goes to the myth of self-regulation that was written about. There are some the ABA rules and the use of the ABA rules and the court's use and the court's applying such rules and the states adopting such rules. That's supposedly what they say is the myth of self-rule amongst the legal community. Number 6 is to comply with other laws. So it shows that there are other laws and things like that outside of the community. To detect or resolve conflicts of interest arising from the lawyer's change of employment. Okay, let's keep going on. Okay, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Okay, so you're not supposed to disclose stuff except under certain discussions, and you need to guard that information as well. All right, so this past rule that we just talked about, the rule we just went over, confidentiality of information. Well, what's the difference between a privileged communication versus confidential information? Let's fix that. Okay, so the privilege applies only if the asserted holder of the privilege is or sought to become a client. Okay, so this is a client's privilege. Now, the person doesn't have to have become a client, but they could have been seeking legal advice with the possibility of becoming a client. And the information, the person to whom the communication was made, so a client, prospective client, one who sought to be a client, it's the client who's providing information to a lawyer, okay, as a member of the bar, as a subordinate, and is acting as a lawyer at the time. So acting concerning, possible representation, providing legal advice, but acting within the confines of being a lawyer. The communication relates to a fact of which the attorney was informed by his client without the presence of strangers for the purpose of securing primarily either an opinion on law or legal service or assistance in legal proceeding, and not for the purpose of committing a crime or tort. So basically, this is a communication by a client or one who has sought to become a client to a lawyer who's acting within his capacity. It's not with, and there's a expectation of privacy within the communication. It doesn't mean that only the lawyer has to be the one hearing the communication, but it can't be within strangers. It can't be in the earshot and heard by those outside of any type of representation for the client. So, for example, if there's a paralegal in the room, well, that continues to be a privileged communication. Okay, the privilege has been claimed and not waived by the client. So you can waive this privilege, but it is the client's privilege. It is not the attorney's privilege to waive. You can claim it and you don't, and it's not waived by the client. Okay, now let's go to the privilege communication verse. Let's fix this again. Verse confidential. Okay, confidential information. All right. This rule governs, okay, this is a comment, the disclosure by a lawyer of information relating to the representation of a client. So it's information, it's not a client's statement to a lawyer. The confidentiality rule, for example, applies not only to matters communicated in confidence by the client. So the privileged communication is confidential information. But confidential information also includes information relating to the representation of the client, whatever its source. And here's an example. So for example, a lawyer who represents a client in a divorce matter and who discovers information about the client's relationship with the client's wife while talking to the client's neighbor has a duty to keep that information confidential. Thus, the example is the information came from someone other than the client, but it concerns the representation and was found out during the representation and as part of the representation of the client, and therefore that becomes confidential information. We also have the work product doctrine. You'll see that in the California case that you'll get. It says work product refers to the writings, notes, memoranda, reports on conversations with the client or witness, research and confidential materials that reflect an attorney's impressions, conclusions, opinions, or legal research or theories. Work product materials are confidential and are not required to be submitted in answer to the discovery request or subpoena. Okay, so this privilege against disclosure belongs to the attorney. All right. All right, here is California Rule of Civil Procedure, and this is pretty much reflective of all other states. It's a writing that reflects an attorney's impressions, conclusions, or opinions, or legal research is not discoverable under any circumstances. Any circumstances. And the work product doctrine has to do with these impressions, conclusions, or opinions, or legal research in conjunction with possible litigation and representation of the client. Now, there's other types of work product that may be discoverable under certain circumstances. But as you see in the third bullet point, a writing that reflects an attorney's impressions, conclusions, or opinions, or legal research is not discoverable under any circumstances. Okay, and work product doctrine is confidential information and is privileged information as well. Okay, we will be looking at declining or terminating representation concerning one of the discussion problems as well. The discussion problem has an interesting twist in it, so we'll see how we can go through that in class. But it says, except as stated in paragraph C, a lawyer shall not represent a client, or where representation has commenced shall withdraw from the representation of a client if the representation will result in violation of the rules of professional conduct or other law. So if the representation, if you have to violate your rules of professional conduct, or you have to violate other rules, you must withdraw. Also, if you're not capable mentally or physically, then you must withdraw. Or if the lawyer has been discharged, then you must withdraw. Now here in B, a lawyer may withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interest of the client. So basically, one, you don't have any other reason. Maybe you're too busy. Maybe you just want to retire, whatever. And if you're able to withdraw without adversely affecting a material adverse effect on the interest of the client, then you can do so. D is if the client persists in an action involving lawyer service that the lawyer reasonably believes is criminal or fraudulent. The client has used the lawyer's service to perpetuate a crime or fraud. The client insists upon taking action that the lawyer considers repugnant or with which the lawyer has fundamental disagreement. The client fails substantially to fulfill an obligation to the lawyer. Number 6, the reputation will result in unreasonable financial burden on the lawyer. Or 7, other good cause for withdrawal exists. So these are exceptions. A lawyer, B is when you may withdraw. A is when you must withdraw. Okay, declining or terminating representation. All right, comment 2, and of course these are all in your book. Selective Standards on Professional Responsibility. They're also on the internet at the ABA site if you want to look at it there. It says a lawyer ordinarily must decline or withdraw from representation if the client demands that the lawyer engage in conduct that is illegal or violates the rules of professional conduct or other law. Okay, so they must decline or withdraw if the client insists or demands that the lawyer engage in unethical or illegal conduct. However, it says the lawyer is not obliged to decline or withdraw simply because the client suggests such a course of conduct. All right, so if the client comes in and says, hey, how about we do something? I want you to do this for me. What do you think? Just because they are suggesting that you do something doesn't mean at that time you say, I quit. Okay, it says a client may make such a suggestion in the hope that a lawyer will not be constrained by a professional obligation. So, for example, they come in and say, hey, I want you to do this for me. Your client's not a legal expert, so you can say to them, I can't do that because of certain constraints based upon the law. Okay, now we go scope of representation and allocation of authority between client and lawyer. Okay, this is concerning the client-lawyer relationship, as 1.16 did, the client-lawyer relationship, whether to decline or terminate representation. Okay, D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. Okay, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. So it can assist a client in breaking the law. However, it can talk to a client about, hey, if you want to do this, these are the consequences. And of course, if they continue to do it based on 116, you must withdraw, or you may withdraw. All right, comment 9 for Rule 1.2. It says paragraph D, that's paragraph D there, prohibits the lawyer from knowingly counseling or assisting a client to commit a crime or fraud. So you never want to do that. This prohibition, however, does not preclude the lawyer from giving an honest opinion about the actual consequences that appear likely to result from a client's conduct. So, for example, if they come in and say, I'm thinking about doing this, and you know that it's a crime, you can't counsel them or assist them to commit that crime, but you can tell them the consequences if they do. 10. A lawyer may not continue assisting a client in conduct that the lawyer originally supposed was legally proper, but then discovers is criminal or fraudulent. The lawyer must therefore withdraw from the representation of the client in the matter. Okay? In some cases, withdrawal alone might be insufficient. It may be necessary for the lawyer to give notice of the fact of withdrawal and to disaffirm any opinion, document, affirmation, or the like. So you see Rule 4.1 there. Okay, let's move on. Again, we're still with the client-lawyer relationship, and we're in Rule 1.4, communication. It says a lawyer shall consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. So included in previous rules that we talked about, where a client may give an opinion on the consequences of their client's actions, the lawyer also must consult with the client about any relevant limitation on the lawyer's conduct. Okay, and must state, hey, I can't do this because the rules of professional conduct, or there's other rules other laws out there that prescribe me from doing that. So that's a communication that a lawyer must make. Because a lawyer shall consult with the client about any relevant limitation on the ability of the lawyer to represent the client and advocate for the client when such would not be permitted under the rules of professional conduct or other laws as well. Okay, transactions with persons other than clients. So we're going away from the client relationship, and we're going to relationship to other parties. Okay, and this one is applicable for one of the fact patterns discussion problems that we will be speaking about in class. It says a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows or reasonably should know that the document or electronically stored information was inadvertently sent shall promptly notify the sender. Okay? All right, so if you are an attorney and you inadvertently, not purposely, but inadvertently receive, and you know it's inadvertent, that no lawyer would be sending, no lawyer from the other side or opposition would be sending you these types of documents, or the lawyer didn't call you up and saying, hey, I'm going to waive my privilege on certain work product. If it's inadvertently sent, once you realize what it is, you need to notify the sender that they sent it to you. It doesn't say exactly what you should do after you notify the sender, but there are constraints on how you can use that information, and if you use it to such an extent, you may be disqualified from representing your client in the matter. Okay, so here are some comments concerning this rule. It says, if a lawyer knows or reasonably should know that such a document or electronically stored information was sent inadvertently, okay, then this rule requires the lawyer to promptly notify the sender in order to permit that person to take protective measures. Number 3, it says some lawyers may choose to return a document or delete electronically stored information unread, for example, when the lawyer learns before receiving it that it was inadvertently sent. Where a lawyer is not required by applicable law to do so, the decision to voluntarily return such a document or delete electronically stored information is a matter of professional judgment ordinarily reserved to the lawyer. So basically, comment 3 says some jurisdictions may require you to act in a certain way once you discover that you have been inadvertently sent some privileged or confidential information, that you must not only immediately contact opposing counsel, but you may be required to delete it, you may be required to send it back, you may be required to destroy it, or some other form of action that's required to you based upon that state's adoption and interpretation and application of its ethical rules. So here's California's law. California doesn't have a specific law or rule of professional responsibility concerning this. However, that doesn't mean there's not a rule out there. There is a rule that comes from the courts, and that rule is when a lawyer receives materials through inadvertence, the lawyer should refrain from examining the materials any more than essential to ascertain if the materials are privileged, and shall immediately notify the sender that he possesses materials that appear to be privileged. And this is a case that originated in the State Comp Insurance Fund versus WPS Incorporated. And the case that I will be sending you refers to this case, cites that case. And this precedent in the California case is pretty much an interpretation or application of the ABA Model Rule 4.4, even though California doesn't go by ABA Model Rule 4.4. Okay, now it comes to the advocate, and this concerns the California case that we'll be going over in class, and that I will eventually send to you before class. Hopefully when you are listening and watching this online lecture, you will have that case and have read it. So, lawyer as a witness. It says a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness unless, and here are three, and these are the model rules, and California has its own rule for this, and we'll look at California's rule. It says the testimony relates to uncontested issues, so there's no worry about credibility or veracity concerning an uncontested issue. It says the testimony relates to the nature and value of legal services rendered in the case. The reason why this is allowed is because the judge makes the determination concerning legal fees and things like that, and they're not going to be swayed by what a prosecutor or an attorney says about this, because the judge should be well informed concerning these issues. Number 3, disqualification of the lawyer would work substantial hardship on the client. This is a messy rule, hard to understand what it is. B, a lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by Rule 1.7 or Rule 1.9. Now, Rule 1.7 and Rule 1.9 are conflict of interest rules, and we'll get into them later in the semester. California rule is the same, has the same rule, but notice in the ABA Model Rule 3.7, a lawyer shall not act as advocate at a trial. So you look at A, at a trial. California Law Rule 5-210 states a member shall not act as an advocate before a jury. So California Rule 5-210 does not, it only is in effect when there's a jury trial, and is not applicable to a bench trial. So that's one big difference between Rule 3.7 of the ABA Model Rules, lawyer as a witness, versus the California Rule 5-210, member as a witness. A member shall not act as an advocate before a jury, as opposed to a lawyer shall not act as an advocate at a trial. All right, so the Rule 3.7 ABA refers to any trial, jury, or bench. California Rule 5-210 only applies before a jury trial. And as you can see, A and B are the same as ABA Rule 3.7, A's 1 and 2, and C is something that's different in another difference in the California rule. It says the member has the informed written consent of the client. If the member represents the people, meaning as a prosecutor or a governmental entity, the consent shall be obtained from the head of the office or designee of the head of the office by which the member is employed, and shall be consistent with principles of recusal. So that's a difference in the California rule. Okay, so that's the end of the week 1 video lecture. These are the rules that we went through and will be going through and applying in class. So read up on those, look at the discussion problems, read the cases, and come to class ready to discuss them. God bless everybody.